referred to in paragraphs 1 to 5 of the request are originals. Of constituency presidential election results in accordance with the various forms that are required to be exhibited. So what we're asking for are originals of these documents. And in paragraph 6, what we are asking for also has to do with the records of the alleged update to the purported declaration. That alleged update is Exhibit B attached to the witness statement of petitioner's witness 1. Your Lordships will see that the figures in respect of that alleged update including the figures of total valid votes cast are different from the declaration that was made on the 9th of December, and which we have provided evidence of as an attachment to the witness statement of PW1 marked Exhibit A. That is a video recording that your Lordships, that the court saw. And there is, again, no dispute that, for instance, the figure of total valid votes cast in Exhibit B is 13,119,460. Whereas what the petitioner stated, what the first respondent stated, which is attached to the petitioner's witness number 1's witness statement at Exhibit A, what she stated the figure 13,434,574. 13,434,574. So there is a conflict between those two figures to start with. But that matter is compounded by the fact that in Exhibit B, a figure is mentioned as what the chairperson of the first respondent inadvertently used, which is again different from what the figure that she actually used. The figure that is now contained in this purported correction is 13,433,573. So we have 13,434,574 on the 9th in declaration as total valid votes cast. Then we have a purported correction 13,119,460, which purports to correct a figure in the declaration and uses yet another figure, 13,433,573. Now, my lords, the point about all these matters is that these figures are supposed to relate to documents that back the figures. They are supposed to relate to documents in the possession of the first respondent that can justify these numbers. These figures are not supposed to be just plucked out of thin air. They're supposed to be figures based on the backing documents. And your lordships will have noted that in our petition, we indicated that if you actually sum up, if you do the arithmetic in respect of the column where votes are attached to individual candidates, if you do that, the figure that you come to is again a different figure. That is 13,121,111.
Thank you, Peter.
Yes.
If you sum up in which document?
In our amended petition in paragraph 12. Our amended petition.
You said if you sum up.
If you sum up
from which table?
That is from what was read. What was
read from the video?
Yes. What was read from the video? Exhibit A.
Exhibit A.
That's right. So we basically listened, took down the numbers, and even though this 13,121,111 did not appear anywhere,
you actually sum up the figures mentioned in Exhibit A,
then
come to
13,121,111.
Thank you.
And we state that in paragraph 12 of the amended petition. So that is a fourth figure. Now, your lordships will note that in the answer of the first respondent, that was filed on the 9th of January. In that answer, the first respondent now actually adopts the figure that we had calculated. And for the first time, the first respondent also states 13,121,111 for the total valid votes cast. So the figure that we have calculated becomes now the basis of the answer. The stone which the builders rejected has become the capstone of the answer of the first respondent. My lords, these are the plain circumstances which necessitate a reference back to original documents which are in the custody of the first respondent. So that there be a proper validation of what the correct number is. My lords, we simply cannot have a situation in which, as described by the petitioner's witness number 1, we still, as at today, cannot tell what the correct figures on the basis of which a declaration has been made publicly. We cannot tell what those correct figures are. We simply cannot tell. And my lords, the only way in which ultimately this court is going to have to satisfy itself in our respectful submission is by ascertaining from the first respondent what exactly its chairperson, who is a constitutionally mandated person, is using for her declaration. And your lordships also have before you a witness statement of the first respondent, which is sworn to by the chairperson, Mrs. Jean Adukwe Mensah, and that is filed on the 22nd of January. And there again, my lords, there is now reference made on oath. Well, I'm sorry, it's not yet on oath. It's not yet on oath. I'm crossing a bridge that I have not got to. But the witness statement, which is already before your lordships, has this number 13-121-111, and that witness statement provides no explanation of how in Exhibit B a different number to be corrected is given from the number that we all heard in the declaration. Yes.
Is that not in paragraph 11? Paragraph 11, the first respondent's witness statement. Is the explanation not there?
My lords, it is not, because, my lords, as I indicated, in the Exhibit B to the witness statement, the number that was given as being corrected is 13433 something something. It is not 13434,574. In the correction that was purported to be made, which I referred your lordships to, and I may go back to it again with your permission, that is the attachment to Johnson Asiedun Ketia's statement, and that is Exhibit B. Your lordships will see that it says the chairperson of the Electoral Commission inadvertently used 13433,573. That is different from the figure that I alluded to, and that is different from what she's referring to in the paragraph that your lordship has referred me to. So, my lords, the reality of changing numbers is inescapable in this election petition.
Mr. Chikata,
yes.
So these numbers are all related to either the total votes or the total valid votes?
That is correct. And CI 127 tells us how those numbers are supposed to be arrived at. CI 127 regulation 4410 requires an assembling and collation of results from the regions provided by the various regional collation officers as set out in Form 12. So, in the midst of the ever-changing figures, it is our respectful submission that there is a need not only to refer to the originals of what she herself purported to use, so that they can be compared to whatever documentation is available to us from the ground. My lords, there has also been, in this case, there has also been extensive cross-examination in respect of Exhibit C, which was struck out, but there was extensive cross-examination in respect of that exhibit. And therefore, my lords, I wish to make reference to that, because the cross-examination purported to show, the cross-examination of counsel for the first respondent purported to show that the two different documents for the Eastern region
My lords, with respect, I never cross-examined on Exhibit C. The exhibit my learned friend might be talking about is Exhibit D, the one that is attached to their letter.
My lords, I do take that correction. It's Exhibit D attached to the letter. Exhibit D. Exhibit D. As in Daniel. There was cross-examination by counsel for the second respondent of Exhibit C, which I will come to later. No, my lord. He cross-examined extensively on it. He did cross-examine on it. But my lord, I will start with Exhibit D, and I should not have said Exhibit C. Now, my lords, with Exhibit D, counsel cross-examined the witness extensively to show or to explain why one document which has a kind of a stamp, a blue stamp, why that document is different from the other document, and that's where you referred to Ayinswanu and all that. Now, my lords, without going into all the details of the figures, I mean, it's clear that it was acknowledged that there were differences between those two. So what we are saying respectfully is that in order even to be clear on what was actually used by the first respondent in reaching the numbers that were ultimately totaled, in order to be clear about that, we would request to inspect the original document that she had. It is no response to say that we have both, simply because we have both documents, both what was originally signed even by our agent, and then another document that was not signed by our agent. In terms of the regional summary for Eastern region. So it's no response to say that we have both, because that's precisely the reason why we need to know which one is the authentic one. And the only way to know the authentic one is if we are allowed to inspect. if we're allowed to inspect the originals that are presumably, counsel for the first respondent who put to the witness certain figures from a certain constituency and all that has had access to those originals, because otherwise he wouldn't put it to the witness. And counsel is only allowed to put to the witness what he has been instructed by his client. So without question, counsel has information which we are not in possession of simply by virtue of having these two contradictory documents, which are Exhibit D, which are attached to Exhibit D, which are attached to Exhibit D. And, my lords, it was explicit in the testimony that was provided by the second petitioner's witness that the agents of the candidate, the petitioner, had issues with some of these collation sheets and began to air them in the discussions to the relevant officials of the EC, and we're awaiting appropriate responses. Now, my lords, as I've said, Exhibit C was also cross-examined upon extensively, and a lot of arithmetic calculations were made in respect of Exhibit C. With different permutations of numbers. And we are saying respectfully that what all that proves is that without knowing the authentic original documents on the basis of which the chairperson of the first respondent undertook her solemn constitutional responsibility, we are all in the dark. Is there? My lords, we are conscious of the fact that in the election petition in 2012-2013, an application was made in a similar manner for documents to be produced for inspection. And the ruling of the court which is found in 2013 Supreme Court of Ghana Law reports at page, the special edition, at page 61 onwards. The ruling of the court states clearly why the lordships on that occasion did not grant the application. And I would respectfully refer to a passage at page 71 of the judgment of the ruling read by Her Ladyship Sofa Adinyira. And she says as follows: in the circumstances, we hold that the petitioners are sufficiently and well informed about the election results, which had enabled them to mount this petition on grounds of malpractices in 4,709 polling stations, based on the contents of these duplicate documents in their possession. In that case, the petitioners mounted the petition on the grounds of 24 categories, as they put it, of malpractice in initially 4,709 polling stations. It became 11,000 by virtue of subsequent amendments, 11,000 and more. And so what the court was there saying is that the petitioners themselves have already put forward, in support of the case, documents that they had confidence in. They had put them forward. And therefore, to ask to inspect documents when you yourself have said, we are putting these forward, and this is the basis of our case, that is contradictory. In this petition, my lords, we have not put forward results or malpractices in 4,709 polling stations. In this petition, we have put forward the words of the declaration of the chairperson, the returning officer, the only constitutionally mandated body. A person, I should say, not even body, the only constitutionally mandated person to exercise that responsibility. And so clearly, the rationale, the ratio precedenda of that case cannot relate to what we are dealing with in this petition. And Her Ladyship goes on to say that the affidavit in support of the application does not disclose any need for the inspection and making photocopies of the originals of the documents. My lords, nobody can say that in this case we are not disclosing any need for the inspection. In a situation where we have changing numbers, and in a situation where to this day we are in no place to state a definitive number. In those circumstances, in our respectful submission, it is actually even in the interest of the first respondent, in terms of transparency, in terms of fairness, it is actually in their interest to make available. That is why, frankly, we did not expect that we have to make this application before that request is granted. We honestly thought that this was something that would be resolved and we would go and have the opportunity to inspect. There are clear provisions in in the rules of court within a reasonable time and within reasonable circumstances, and we cannot obviously flout those circumstances. So this is something that could have been resolved, in a very straightforward manner by enabling that inspection to take place without having recourse to orders of the court. But we have not had even the courtesy of an acknowledgement of our request, and therefore we are obliged to seek the orders of the court in order that we can achieve what will enable us to have a fair hearing of the petition that we brought to this court. Now, if there's nothing to hide in terms of transparency around these originals, it's difficult to appreciate why an inspection could not have been granted in the course of the last 14 days or so since we filed. 12 days to the end of January, so about 15 days. If there is nothing to hide, I mean, if the interest of the first respondent is transparency, as has been indicated, then why would it be so difficult? Why would it be so difficult to allow access to the originals? We haven't come relying on our duplicates saying that they are the basis of our case. We've come relying on her own declaration. Her own declaration speaks for itself. So, my lords, in this situation, we require access to the originals, which we can then compare with what we have and try to get to the bottom of these ever-changing numbers. Now, my lords, the reference that I made to a fair hearing, my lord, is also anchored because we are saying effectively that this access to these documents is required for a fair hearing in this case, because it is not within the province of the first respondent just to pick and choose numbers from different sheets in the way they sought to do in cross-examining on Exhibit D. It's not within their province just to pick and choose and say, oh, this document which you have, it didn't include Ayen Swanu. There's nothing on the face of the document which says Ayen Swanu is there or not there. Nothing. And this one which you also have, which is supposedly about the same regional results, regional collation, that document has different numbers. And we just have to take it from them that Ayen Swanu's 40,000 is what has led to the difference. Well, that is totally unacceptable, with the greatest respect. And Article 19(13) of the Constitution makes it clear that this court is required to give a fair hearing within a reasonable time. May I just, with your permission, read that article? An adjudicating authority for the determination of the existence or extent of a civil right obligation shall, subject to the provisions of this Constitution, be established by law, shall be independent and impartial, and where proceedings for determination are instituted by a person before such an adjudicating authority, the case shall be given a fair hearing within a reasonable time. Now, my lords, as I indicated, we are asking for a fair hearing of the petition that we have brought, and for that fair hearing, we are submitting that the matters that we have, the documents that we have sought access to are necessary documents in order to understand the case that is being put against us, with all its changes and permutations. And so it's our respectful submission. And my lords, I may just make a comment finally on 6. The request in 6, that is not dealing with originals, that is dealing with records of the alleged update to the purported declaration. Now, my lords will observe that that update, Exhibit B to PW1's witness statement, that update is not signed by anybody. It's a press release, and we do know. Okay. Yeah. That update is not signed by the chairperson. It is not signed by anybody. And we do know, my lords, that the constitutional role that is assigned to the chairperson, both under the Constitution and under CI 127, that role cannot be delegated either to a media relations officer or to a deputy or any other person. It cannot simply be delegated. And therefore, how the records relating to that alleged update are things that need to be inspected, particularly when we have pointed out to your lordships that in that update itself, certain figures are put there which are different from what we all heard in the declaration. So some records are required, and no doubt there must be some basis internally for the alleged update, and that's the essence of what is in paragraph 6, as distinct from paragraphs 1 to 5. It's our respectful submission, therefore, that in the interests of justice, this application be granted. And I would also just conclude with what is provided in Order 1, Rule 2 of CI 47, that these rules shall be interpreted and applied so as to achieve speedy and effective justice, avoid delays and unnecessary expense, and ensure that as far as possible, all matters in dispute between the parties may be completely, effectively, and finally determined, and multiplicity of proceedings concerning any matters avoided. Indeed, this proceeding, in our view, is really quite unnecessary because it could have been dealt with expeditiously. My lords, I omitted one point in their response that I just want to comment on in one sentence. Both responses begin to raise issues about burden of proof in the case and so on. In our respectful submission, issues of burden of proof are irrelevant to the inspection of documents. The burden of proof in this matter is something on which no doubt we'll have occasion to address on different aspects. Whether the burden of proof is on us to do this or that, those are matters that at the appropriate time we'll deal with. But in their affidavits, essentially, they are laying claim to some view of burden of proof, which is legally very suspect, but on that basis, they are saying that this application should not be granted, and we feel there is absolutely no basis for that.
You refer us to Order 9, 1. Can we take a look at Order... No, you refer to Order 21, Rule 9. Can we look at Order 21, Rule 11, and if you may address us on it? Since I believe the primary objective of this application is to determine the total valid votes cast. That's the primary objective. Your application, yes, is to determine the total valid votes. No.
We cannot be limited to just the total valid. I'm sorry. Yeah. My lords, this application is not just the determination of the total valid votes cast, because the total valid votes cast goes back to whatever was happening at the regional collation, that is the Form 12 that is referred to, and about which there's been evidence that there was some dispute about that. So it is not just the total, it's also to do with the allocation of the votes. Your lordship will see that in the Exhibit D attachment that we have, there are differences in the allocations of the votes cast. So it cannot just be in respect of total valid votes cast. It cannot just be.
Can you look at Rule 11? Rule 11, sub Rule 1.
Order 21,
Rule 11.
Rule 11. Production to be ordered only if necessary. Yes, my lord. An order for the production of any document for inspection or to the court shall not be made under any of these rules unless the court is of opinion that the order is necessary either to dispose fairly of the cause or matter or to save costs. And then 2, where on an application under this order for production of a document for inspection or to the court, privilege from the production is claimed or objection is made to the production on any other ground, the court may inspect the document to decide whether the claim or objection is justified. I don't believe that privilege is an issue here.
Referring to 1?
Yes. And 1, we have addressed you on the necessity, and we have addressed you by referring even simply to the attachment to Exhibit D, which has been the basis of a lot of cross-examination here and the basis of a lot of explanation from counsel. But that Exhibit D itself, in our respectful submission, shows the necessity for knowing what is the original document on the basis of which we must choose one or the other. What is the original document? That is my submission.
I have a question. When you go to inspect them, what will you be doing?
Well, we'll be comparing them with documents that we have, which we regard as authentic, to see whether indeed they are the same. That's what we'll be doing.
But you don't see the need to tell us what you have as your valid vote?
No, we do not have the need, because we are not the returning officer, with the greatest respect. We are not the returning officer. And my lords, with the greatest respect, this is quite an important point, because His Lordship Justice Appel did ask certain questions in relation to PW1, and in our respectful submission, those questions are completely irrelevant to the issues that have to be dealt with. Because the question whether he has documents or
My
not.
lords, if I may be heard on this. My lords, I think counsel should argue the application before he... Yes, but the question had nothing to do with what Justice Upper said.
Let me answer myself.
No.
Please. Mr. Chikata, please. That is your opinion. So you keep it to yourself.
Yeah,
Whether the questions I asked were irrelevant or not, that is your opinion.
Yeah, but my lord, I need to explain why I'm saying they're irrelevant, so that I can fully answer the question. Because the question relates to the same position that your lordship took. The question relates to that. So I need to be heard on why I say that they're irrelevant, because I do not say that lightly. I do not say that lightly. I do not say that lightly. The questions are irrelevant because we have brought a petition here on the grounds of a declaration that was made purportedly about elections held on the 7th of December. The declaration stated a figure. We all heard it, 14,300 and 400 and all that. We all heard it. That declaration to this day is the only declaration that has been made. Johnson Asiedu Nketia is not the returning officer of the election of 7th December. That is all.
We are opposed to this application. And my lords, we rely on all the depositions in the affidavit in opposition. My lords, under Article 64(1) of the 1992 Constitution, the petitioner has had 21 days from the date of the declaration to file this petition. Because we have not been told in this court that between the time of the declaration to the time the petition was filed, any such request has been made. And Lord, secondly, the question is asked, why is this application being made on the 34th day after the petition has been filed, when hearing is well underway? My lords, if you peruse Exhibit Inspection 1, the document filed purports to give the first respondent 3 days from the date of service to comply. Lords, with the greatest respect, there is no such rule of this court under which this application was made, or even under the High Court rules. Yes, but my lords, even so, it talks about 14 days. Mutual discovery talks about 14 days, my lords. Lords, I say this because under Rule 5 of your rules, oh sorry, my lords, of the Supreme Court rules, with your kind permission, if I may read, where provision is not expressly made by these rules regarding the practice and procedure which shall apply to a cause or matter before the court shall prescribe the practice and procedure that, in the opinion of the court, the justice of the cause or matter requires. And Lords, there have been several authorities on this point that it is the court that you make an application to for guidance in this matter. Lords, with respect, if I may refer you to the case of Cogles Ghana Limited number 2 versus Atier number 2 2003-2004 Supreme Court of Ghana Law Report at page 75. Lord, with respect, Agree DSC, speaking for the court, said this, and with your kind permission, if I may quote it. I hold a view that the application before us cannot be entertained under Rule 5. In my opinion, where a party has difficulty or is in doubt at what steps to take, where there are no express practice of procedure provided, the party must apply to the court for directions rather than, and this is my emphasis, rather than arrogate to himself the powers given to the court under Rule 5.
Mr. Amenuvo.
Yes, my lord.
You see, he came under mutual discovery. That is order 21-1. Yeah. Then when you look at the proceedings, we've gone beyond that because there was no response from you. And when you do not, allow inspection or whatever of documents, then you can resort to an application under 21-9.
Yes.
And this is the application you are determining. Yeah. So look at the Cogles case again, whether you can look at 5 of the CI system and apply it to the circumstances.
So my lord, I refer to the Cogles case in order to make the point of the timing of this application.
The timing?
Yes, my lords. The timing of this application.
Do you have any time frame after the failure of mutual discovery?
My lords, when you are proceeding.
No. Respond to the question. What I'm saying that beyond mutual discovery, do you have any time frame set down under Order 21?
No, my lord, you have to apply to the court.
And this is the application you are determining.
Yes, my lord. The point is that the point is that where CI 99, under which the presidential election petition is filed, talks about timeousness. Then, when you make an application at a particular point in time, in responding to the application, with the greatest respect, the court, we are entitled to make the point as to the timely nature or otherwise of the application. Lord, the second point I wish to make is that the petitioner has failed to prove that the production for inspection by the first respondent is necessary in these circumstances. Lord, this is because the witnesses themselves who came to testify on behalf of the petitioner themselves admit that they have the documents. And Lord, the way this process is that once the document is filled out or the agents are given the carbonized copies, and we did ask them, both of them, that do you have the documents? They said under oath that we do have the documents. So therefore, if you do have the documents, on what basis is this application being made? My lords, furthermore, it's our submission that the situation is that the petitioner has failed to provide any evidence in support of his petition. And that is why, at the end of the cross-examination of the petitioner's witnesses, this application will be brought in order to give them the opportunity to lead further evidence. I do not believe that it has been the practice of our courts that evidence is led in piecemeal. Evidence cannot be led in piecemeal before the High Court, how much more the Supreme Court. So, my lords, it is our submission that for these grounds, And of course, they bear the burden of proof to provide evidence sufficiently for the burden to shift. They have it, and having failed to do that, they cannot, at this late hour, come and make this application for documents which the witnesses themselves admit are in their possession. That is our submission, my lords.
My Lord, we believe that at the heart of this application is the question of which party bears the burden of persuasion and the burden of producing evidence. Now, my lords, I say so because the petitioner, by the admission of his own witnesses and by law, has photocopies of all carbonized copies of all the processes, copies of all the documents through carbonized copies. Therefore, where the petitioner raises a question about the authenticity of any document, he must first produce what he has and show that what he has is different from what the other party has. Secondly, if it is in respect of the declaration, the petitioner has all the documents that will enable him sum up the results, the national results of all the candidates. He has the carbonized copies of relevant documents that will enable him sum up the total number of valid votes he got, the total number of valid votes the second respondent got, and the total number of valid votes the other candidates had. My Lord, the petitioner, for reasons best known to himself, has refused to present this before the court when he bears the burden of proof. He has refused to take any steps to meet that burden. He has refused to produce any documents to meet his burden of producing documents. Then he turns round and under this guise of application to produce evidence, he's saying that produce a document. He's trying to garner the evidence that he used to prosecute his case. My Lord, this, with all due respect, is a totally misconceived procedure. My Lord, let me say again that it is not as if the petitioner is saying that from the documents I have, the documents that the EC is producing is not the right document, and therefore we want to see the original because we have the exact carbonized copy of what the EC has, and what it's producing is different from what we have. He's not saying that. Rather, the application confuses authenticity because you are questioning the photocopy as not the original, the carbonized copy as not the original. And where the document is authentic, but you are taking issue with the contents, it's a different matter. If the document is authentic and you are taking issue that the content, you have a problem with it, it's a different matter from saying that it is not authentic. You can only raise the question of authenticity if you have some other document which is showing that this cannot be the authentic document. And say that nobody can quarrel with the petitioner where he says that I have problems with the content of the document. If you have problems with the content of the document, produce the carbonized copies which will show that the contents of the document are wrong. And that is why, my lords, at the heart of this application is an attempt to shift the burden of proof and the burden of producing evidence onto the respondents. And that is never possible in any court of law. My lords, again, we wish to make it very clear that it is not the number of times that counsel refers to transparency that would make his case that things are not transparent. He needs to provide the evidence of lack of transparency and not just the verbal statement about transparency and repeating it over and over again. Then again, my lords, the petitioner makes a very curious statement about fair hearing. My understanding of his submission is that he's using fair hearing to conjure away the burden of proof. Conjure away. He's using the right to a fair hearing to My lords, with all due respect to your lordship, with all due respect to your lordship, I think what I'm saying is appropriate, given the context. I'm saying, my lords, with all due respect, that the applications seeks to use the right to fair hearing to conjure away the burden of proof and the burden of persuasion. These are very fundamental issues in a trial process. He cannot shift the burden of proof when he has not led any evidence which compels us to lead evidence in response. He has not adduced any evidence, much more met the burden of proof. That is all the time on him. So, my lords, if this is the reason for his application, my lords, it is a misconceived application. My lords, what makes it worse, my lords, is that he has not met the basic conditions set up in Order 21, Rule 11, 1. 21, Rule 11, 1. 11.1 of CI 47, which reads, with your permission, as follows. An order for the production of any document for inspection or to the court shall not be made under any of these rules unless the court is of the opinion that the order is necessary either to dispose fairly of the cause or matter or to save costs. My lords, it's our submission that the council has not shown in any way whatsoever the necessity of this application. Furthermore, he has not demonstrated how this will aid the fair disposal of the application or save costs. It will not help save costs because indeed, if the application is granted, it will rather increase the cost of litigation. It will not promote a fair disposal of this this petition because the application is misconceived. Being misconceived, it cannot promote the fair disposal of the cause or matter. Now, we believe that the council was right when he referred to the decision in the Supreme Court of Ghana Law Report Special Edition 2013, where at page 7 thereof, the court, speaking through Sofadina JSC, made the following points, and I quote: the guiding principle, page 70, my lords. My lord, counsel was right in the quotation, but he was completely wrong in the gloss and interpretation he sought to put on the text. My lord, I read the text. Quote: the guiding principle in the instant application, which is an application for production of documents or inspection, is whether the order is necessary records in the official custody of second respondent, Electoral Commission. The petitioners, as well as the first and third respondent, like all other political parties and independent candidates that contested the December 2012 presidential elections, were given duplicate copies of the same documents through their representatives at the polling to make an order for the inspection and making copies of the document in question. Then the court makes a very important point. By virtue of the Evidence Act, the Electoral Commission now, the court continues. Petitioners have not raised any concerns about the duplicate copies given them at the collation centers. And they can't raise those concerns because they have not introduced those documents before your lordships. So they cannot raise concerns. So that is why this application is thoroughly unmeritorious and should be dismissed as such.
My lords, may I just, with your leave, I just wanted to indicate in respect of the point, may I, with your leave? Yes, my lords, it's been suggested that we must first produce what we have before we ask for something. There's nothing in Order 21 that...
My lords, that's not what I said. You should not misinterpret me.
That was... And my lords, as far as the carbonized copies being available are concerned, that's exactly the problem. We've indicated with examples that we are confronted with a situation which needs to be clarified.
No, my lord, you can only respond on legal issues. He's introducing facts.
Sit down. Please sit down. We will have.
All right.
and all. So once he receives this, the respective regional calculation officer, a number of things must be done in the presence of the public and with no more than 2 counting agents of the parties or the candidates in question. So first and foremost, he must assemble and collate the presidential results from the constituencies in that region as is set out in Form 10, the summary or the collation that he's received, and then fill the presidential election results collation form. That is Form 11. And Form 11 provides, that's one of the forms that are being requested as well by the petitioner for inspection. It provides for the listing of all the constituencies in a particular region with the total valid votes cast for all the candidates, as well as the total rejected ballots and the total votes cast generally in that region must be recorded on Form 11. And once this is done, the regional collation officer, once this is done, yes, the regional collation officer will then proceed to fill the summary sheet, Form 12, that's the Presidential Regional Results Summary Sheet, Form 12. And this Form 12 then provides, what if they refuse to sign, there's an opportunity for them to provide reasons, and then the results will be announced publicly to the hearing of the public. A copy of the summary sheet, Form 12, will once again be posted at the regional office of the Electoral Commission, and then the regional collation officer will proceed to forward the summary sheet to the chairperson of the Electoral Commission in Accra. So once the chairperson receives the Form 12s from all the regional collation officers in all the 16 regions of Ghana, in the presence of the public and with no more than 2 counting agents of the candidates in question, the EC chair, who is the returning officer for the presidential, which is one of the other documents the petitioners are seeking to inspect. And Form 13 has the same, the name of all the regions of Ghana, as well as the votes, the names of all the candidates, the votes that have been received, valid votes that have been received for all the candidates, the rejected ballots and the total votes and so on and so forth. Then there will be a request for the representatives of the candidates to sign Form 13. Or if they do not want to sign, there's also a portion in there where they can state their reasons for refusal to sign. It is after this that a declaration of the results of the presidential election will be made by the returning officer of the Electoral Commission, after which a copy of Form 13 will be posted at the head office of the EC, and then subsequently the final task that the Electoral Commissioner has to do is to make a constitutional instrument pursuant to Article 63(9) of the Constitution, where she would name a person in that instrument as having been validly elected, and that's prima facie evidence of that person being validly elected. And we saw that being done by virtue of CI 135, which named Nana Addo Dankwa Akufo-Addo as the person who was validly elected at the elections that were held. So that's the background and the context that we need. So the application that is before...
And there was another request for the updates too.
Yes, and the updates of the regional, the declaration, and the fact that there were 4 constituencies in the Greater Accra region that impacted the overall results. Yes, that's also there. Thank you for the reminder. So the application now that is before the court, the petitioner grounds it in Rule 5 of CI 16. And Rule 5 of CI 16 gives the Supreme Court the power to prescribe the practice and procedure that will be adopted for the purposes of causes or matters before the court in situations where no provision
has been explicitly made for saying. And we see that going through the Supreme Court rules, there aren't necessarily provisions in terms of discovery, interrogatories, and all those kinds of things. That's why when we were dealing with the issue of the interrogatories some time back, the petitioner was requesting that the court adopt the provisions in CI 47, which is the High Court Civil Procedure Rules, to be adopted in the Supreme Court because of that residual power that the Supreme Court has under Rule 5 of CI 16, which is the Supreme Court rules. They can adopt any practice and procedure which they feel will be necessary to deal with the matter before them, where there aren't any procedure provided for in terms of those matters. So that's what the application is grounded in. And since there isn't necessarily the provision for discovery, which is usually part and parcel of the pretrial hearing process before the High Court, for instance, counsel for the petitioner was of the view and prayed the court to adopt Order 21-1 of the High Court Civil Procedure Rule CI 47, which provides for mutual discovery. So they were essentially, that's what they were asking the court to do, and they cited a number of reasons, cited case law that, in their opinion, supports the application and things of that sort. But we saw that counsel for both respondents vehemently objected on various grounds as well. That, for instance, that the petitioner was trying to shift the burden of persuasion as well as the burden of producing evidence and things of that sort. So that's where we are at this particular point in time. Petitioner is requesting to inspect the originals of the document, the various forms that we just talked about, and the respondents are opposing that application on a number of reasons. The fact that they already have copies of these. And we saw that one of the judges even asked an interesting question about why or how the petitioner doesn't want to disclose their own results that they have obtained, because the idea is that they have copies of all the forms that they are requesting to inspect, but they want to now proceed to inspect that which is in the custody of the Electoral Commission. And so now all we have to do is wait for the court to come out with this ruling on this particular matter. But in general, these are the issues that are at stake. These are the processes that are taking right from the polling station level to the constituency, to the regional, to the head office of the Electoral Commission. So it seems as though there's a transparent process that involves the public, that involves the agents of or representatives of the various political parties and candidates, all the way up until the declaration of the results are made by the EC chairperson.
Okay, help us to understand this. Let's look at some of the CIs, like CI 47, which is the High Court Civil Procedure Rule. Just educate us a bit, whether you can use the High Court in the Supreme Court.
So,
not to
that's
this
what I was saying. No, sorry. So the point is that all the various courts, so the High Courts, they are the High Court rules, Civil Procedure Rules, as we know, CI 47, subsequently been amended by CI 87. There's a Supreme Court rule, CI 16, subsequently amended by CI 74, CI 98, and CI 99. And what these rules do is that they provide the rules by which you are to conduct cases before the specific courts. And so when it comes to the Supreme Court rules, there are a number of rules that are provided, but it seems as though, and the CI 16 itself, by virtue of Rule 5, recognizes the fact that it may be possible that in terms of certain matters, specific rules may not have been necessarily provided for in the Supreme Court rules, and in those peculiar circumstances, the Supreme Court, if it deems it fit so to do, can adopt whatever rules of practice and procedure that they believe are necessary and will help in the dispensation of the matter that is before them. And it is on that basis, for instance, that the petitioner initially made that application for the service of interrogatories on the first respondent, because interrogatories or service of interrogatories are not necessarily provided for in the Supreme Court rules. But in the High Court rules, it's part and parcel of the pre-trial process. So what the petitioner was requesting then was that because they felt that those responses to the questions or the interrogatories that they wanted to serve on the first respondent will aid them in settling on the issues, for instance, and also their witness statements, they were requesting that the court adopts that process under CI 47 within the Supreme Court. And that's a similar thing that they're doing here, asking the court to use its power by virtue of Rule 5 of CI 16 to adopt the process under CI 47, which will usually be what will transpire before the High Court, the issue of mutual discovery, where parties can exchange documents or request to see documents that are, or inspect documents that are within the custody of other parties, so that it is fair, you are not unduly surprised, and things of that sort. That's the essence of mutual discovery. But the court can also order discovery to be done upon an application to the court as well. So that is what the whole process is. It's not as though the court definitely does have the power. Whether or not they would uphold or grant the request or the motion that the petitioner has moved, it's a thing that only the court can do. But going by the rules under the Supreme Court rules, the court has the power to prescribe any procedure that can be undertaken if it will help dispense of the matter in a fair and in a speedy manner.
In granting applications, not necessarily this kind of application, but applications in general, aside the various rules which are under the various CIs, are there any other grounds that the court also looks at before it will grant or not to grant an application?
I mean, if it's, and we saw, for instance, that one of the justices referred counsel for the petitioner to Order 21, Rule 11, which is the production to be ordered only if necessary. So if the court deems it is necessary to grant that respect for that request for inspection of documents or discovery in that particular regard, the court can do so. So the whole idea is that it is to aid in the dealing of the matters that are before the court, the speedy dispensation of justice, as well as providing a fair opportunity of all the parties to obtain or inspect documents that are within the custody of the other parties. That's why there's even mutual discovery, Order 21 So even before you apply for a court order for discovery, the parties can agree to mutually engage in this discovery process, or even waive it if need be, so that the matter can proceed.
All right. So let's assume if it's granted, what does it mean? If it is not granted, what does it mean? And what will be the way forward after?
Not to be prejudicial or try to preempt what is going to do, but generally speaking, seeing where we are at this particular point in time, the fact that an application is being made at this stage, and that's one of the things that respondents even touch on, the fact that the application is being made so late when pre-trial is even done and the hearing is actually ongoing and things of that sort. But a number of things that we can think about, generally speaking, because yesterday we heard counsel for the petitioner suggest, and correct me if I'm wrong, but I heard something to the effect that the reasons why they are requesting these to inspect these documents could be or are to ensure that they are able to know whether or not they could file additional witness statements, for instance. So it didn't seem as though they are done with their case yet, and that whether or not they will file additional witness statements will depend on the decision of this matter, or the ruling on this matter. Because you remember that initially in the petition, it was suggested that they were going to rely on 5 witnesses or call 5 witnesses. But we saw that once they were made to file their witness statements, there were only 2 witness statements that were filed. The 2 witnesses, their testimonies or their witness statements have been adopted. They have been cross-examined upon them end with this, that they have been duly discharged. Yesterday, the second witness for the first, the petitioner was discharged, and so that brought those matters to an end. And that's when we saw this application being made, or this notice of this application being given, and it subsequently being moved in court today, and the opposition and all that in the court about to give its ruling. So it could mean, looking at it generally and on the basis of what is publicly available, it could the decision one way or the other, and we are in no position to know what the court will decide, but one way or the other would probably impact on the basis of what the petitioner themselves or the counsel for the petitioner himself has said in open court, the hearing of the public generally. It could impact whether or not they are done with their side in terms of the witnesses that they put forth to make their case on their behalf, and so that we can move on to the respondents, or whether or not they would file an additional witness statement, call another witness that will testify either orally or through the witness statement, which has been the norm in this particular process, and the cross-examination can take place before we move on to the respondent. So two things that can happen. Either the petitioner is going to continue with its case through other witnesses that may be called to testify or through their witness statement, or we're probably going to move on to the respondents' testimonies through the witness statements and subsequent examination and things of that sort.
For an inspection to be granted, does the court have any rule or any procedure on how the inspection should be done? I remember 2012, 2013, there was a request for an audit and all that, and a third party was brought in to help with the auditing process. For an inspection to be granted, if it's granted, and again, I mean, not trying to go into the case, is there any particular way or rule that the court has for such thing to be done?
I mean, if it's by virtue of mutual discovery or even by a court order, you'd have to make those documents available to the other party. There isn't any particular, to my mind, that maybe you should meet at this particular place to do it, or any of those things, but you should generally make those documents that are within your custody or are in your custody available for inspection to the other party, obviously within the time frame that the court sets for that to be done, so that we will be able to deal with the matter that is before the court. And we need to also understand that we are working within a time framework that has been given by CI 99. So I believe that without prejudice or without preempting anything that the court will decide on this particular matter, some time frames will be given, and as we've been seeing the court do that, anytime it directs the parties to do certain things, it gives a general guidance in terms of the time frame for which it's supposed to be done. And I think this is not going to be any different in terms of what is before the court. But in terms of actual, the court given directions in terms of what or how it should be done, I mean, we probably have to wait to hear what the court says. But generally speaking, if discovery is supposed to be undertaken, the parties in good faith will have to ensure that the other side has access to the document that is being referred to once the order has been given, for instance, or if it's by virtue of mutual agreement, then the parties can decide on how to undertake or how to go about that particular process.
All right, for legal education's sake, if you talk about discoveries, what does it mean? And there's also mutual discoveries. What does it also mean?
So when we talk about discovery, it's the process whereby you make available documents that are in your possession that are pertinent to, say, some facts that are in issue in that particular instance. So if in this particular case, for instance, which we can use because it's publicly available, the specific documents that the petitioner are requesting to inspect are those documents that we just talked about from 9, 10, 11, 12, and 13, for instance, which originals of which are within or in the possession or custody of the Electoral Commission. That is clear because we know that at every stage of the process, the Electoral Commission or officers of the Electoral Commission were made to fill these forms for them subsequently, all the way up until it gets to the Electoral Commissioner herself that the declaration is done. So these will be the documents that are in contention, and the petitioner's case seems to be premised on the fact that there were certain mistakes or certain errors that go to the heart of the declaration and go to the heart by necessary implication. And I'm just paraphrasing what the petitioners have said. But go to the heart of the matter in terms of the validity of the election results itself. So those will be deemed to be facts in issue, and they then want to inspect those documents to see if it tallies with the counter documents, not the counter documents, the carbon copies that they have in their possession, that they ought to have in their possession. And that's why we saw even an issue being raised as to why they are not, because you're challenging the validity of the election results, suggesting that no one got the threshold or met the Article 63 threshold, but are not necessarily providing any figures, if you may, as to what the parties must have gotten. Because the Electoral Commission's declaration was clear that one candidate got over 51% of the total valid votes cast. And the petitioner is saying no candidate got more than 50% of the total valid votes cast. And in so doing, they then want to inspect documents in the custody of the Electoral Commission to probably reconcile with the figures that they have. But they feel that it is not in their, or it's not their job to provide any figures to any of the parties or to the court for that matter, because, and that's what was said in court today, that they are not the returning officer and have no such duty to put out figures or anything of that sort. So that's generally what discovery is. If you have documents in your possession that are key to the issue before the court, I also have documents in my possession that are key to the issues before the court. And so we all exchange documents or inspect documents to see, to compare and to see what documents you have in your possession and things of that sort, so that it ensures that once the matter, the hearing is ongoing, we are not unduly surprised, and we know the kind of documents that you may confront us with. I also know the kind of documents that I may confront you with and things of that sort. So it's all part and parcel of the process of ensuring that justice is done and seen to be done as well generally in court processes. But obviously in election petitions and in the Supreme Court, the court has the power to determine whether certain things can be done or can't be done. We saw the citation of the 2012-2013 election petition where such requests were not necessarily granted, and there were some distinctions that were the counsel for the petitioner, I believe, tried to draw from that particular instance and this particular instance as well. So at this point in time, all that we can do is wait for the court to give its ruling on this particular matter so that we know how we're going to proceed. But generally speaking, that's what discovery is all about.
Is this same for mutual discovery?
Oh yeah, that's what I was talking about, mutual discovery, where the parties themselves agree. It's not in dispute or anything of that sort. So you can even dispense with the discovery if you feel it's not necessary for the purposes of the case. But the court can also grant or order discovery, assuming that mutual discovery has not been agreed upon. So those are the two things that can generally happen. And we saw, for instance, that it's suggested, and the CI-47 itself suggests that it is only when it is necessary that the court, if the court's of the opinion that such an order for discovery is necessary, that it will ensure the fair disposition of the matter, that it will order discovery to be made. So it's not necessarily as of right, if we may put it that way.
Right.
It's discretionary.
Still within the whole legal education and the discoveries. If the other party does not have a copy of that whatever document is being asked for, does it also mean that the discovery is cogent enough? and let's assume that the other party also has got the same document that is needed for. Where does discovery become very strong for one to really rely on?
George, I see where you're going. I see where you're going with this question, and I refuse. I refuse to be. I won't be tempted by your invitations to delve into certain matters. That we can simply wait and hear what happens when once the court is back and gives its ruling on the matter.
Okay, and all this is happening within the 42 days.
Yes, because that's what CI 99, which is the rules that provide for the speedy dispensation of an election petition, that's what it provides. So generally speaking, we're working within the time frame that has been provided by CI 99.
All right, help us to understand. I know we've touched on this before, but just help us to understand as we conclude and wait for the judges to return. With the 42 days, has it got to do with the number of days that the court sits, or the days when the court even does not sit? It includes the 42 days.
So Rule 69 C4 of CI 99 provides that the court shall inquire into and determine the petition expeditiously, and the time for the processes in relation to the petition shall be specified in the second schedule. That's what Rule 69 C4 says. If you look at the second schedule of CI 99, it provides the timelines for the determination of the presidential petition. It provides for processes that ought to be done, as well as the time frame within which it has to be done. And for instance, it talks about the fact that filing and service is done in January, or the duration for filing and service is January. And on the 7th day, supposed to be appearance and answer. On the 10th day, it's pre. Trial. 15th day, hearing begins. 20. The first day, end of hearing. And on the 42nd day, judgment is given, and the time frame, or the time that has been apportioned to the 42nd day and judgment given. It says March, and that's what the CI says. I'm holding it up so that you see these are the words. These are what CI 99 is saying in terms of the time frame for which the matters have to be dealt with. So it seems as though March is the 42nd day will fall in March. I mean, so I can't say that 42 days are consecutive or 42 days are sitting days, or the 42 days probably will be the days on which I mean, I don't have any authority to pronounce on these things, but just by looking at what CI 99 is saying and looking at the timelines that it gives, it says clearly that the 42nd day is in March.
All right, we'll leave it here. But my usual side questions. This is my usual side questions, not necessarily pertaining to. I mean, does it go that slow in court when proceedings like this are going on? Because sometimes it gets a bit, I wouldn't use the word boring, but for a lack of a better word to use, boring. Does it go like that usually in court?
Oh, but this has been fast. I mean, the election petition has been fast. This proceeded, we are almost at the point gated for a very long time. But once again, it depends on the type or class of cases that you're talking about. So we know, for instance, that some land disputes span many, many years because of the many, many things that happen before court and outside and things of that. So it really depends. I can't say that it's usually slow or fast and all that, but in terms of but it's definitely not boring. I mean, I think you've been excited about this particular election petition, even trying to preempt or trying to jump to or try to get some sense of where it's going and generally following and all that. So boring is not a word that I'll use. Exciting is the word that I will use in terms of trying appreciating and understanding what is actually taking place and the fact that justice is being, we're seeing the manifestation of justice in front of us and to the whole world. For that matter, it can only go to our credit as a nation and as a people that we resort to such means of resolving different things of that sort. So I think it's exciting, far from boring.
Okay, and I noticed that when counsels from both sides are presenting their case, sometimes the justices will ask them to go a bit slow because there's a recorder who is recording. Does the recorder record everything that's said in court? Everything?
Oh yes, they're supposed to record the submissions that are being made because there has to be an accurate record of the proceedings once it is done and all that, because sometimes the applications and the motions are before the court, but when the arguments are being made, you also sometimes you realize that arguments are made that are not necessarily captured or expanded upon, arguments that have been made in this and the questions that may be asked and the answers to the questions and all that. So it's part and parcel of the whole process to ensure that the right thing is done and there's fairness, so that somebody does not say that this was not said. So remember, for instance, that counsel for the petitioner, in responding to the objection or the opposition that had been raised by the second respondent counsel, not to suggest that the second respondent counsel had said something, and quickly rose to his feet to make that clear that he did not say what he was purported to have said, and clarified that as well. And also the petitioner's counsel, when he was referring to, I think, Order 21 referred to something else, and he had to be corrected, and he admitted that he had made a mistake and all that. So these are things that have to be accurately recorded so that there's no issue as to some of these things that may be peripheral, but someone may stand on it to say that he wasn't treated fairly and things of that sort.
All right. Well, we'll leave it here for now, and we'll wait for the justices to return. When they do, and there's a ruling, whatever happens next, we'll get back to you, that we can wrap up.